This is crazy. I was streaming the Bryan Kohberger updates, and all of a sudden my chat was telling me, oh, there's breaking news that Bryan Kohberger has taken a plea deal. So here's what happened. Recovery Addict says breaking news, BK takes a plea deal. They say that he's innocent. They say, I don't know. I've only heard the defense say that he's innocent, but yeah, link it in the Discord for me. Idaho student murder suspect Bryan Kohberger has accepted a plea deal to spare his life in exchange for a guilty plea in the murders of the 4 University of Idaho students. I was covering the judge's order on not delaying the trial because the trial is set to happen in August and the defense wanted to delay it. And then I wanted to also go over the order with the alternate perpetrators theory because the defense is putting forth 4 alternate perpetrators that could have committed the crimes. Not Bryan Kohberger, but guess what? He pled guilty for the 4 murders today. So I'm still going to go over the court documents because I still think they're really interesting. And I wonder if because the defense kept losing motion after motion after motion, that at some point they had that really serious conversation. I'm sure they did, where it's like, hey, you know, things were really not looking good. Why not possibly consider taking a plea deal? Evidence looks really bad right now. And maybe Bryan Kohberger wanted to take a plea deal. You know, maybe the defense, maybe Ann Taylor was like, hey, you know, like we can do this. We got this, you know, got the trial coming up. And maybe it was Bryan Kohberger and his family were the ones who were pushing to, you know what, actually, maybe we consider doing the plea deal after all. But I don't know. We don't know how it happened. We do know there's a hearing that's going to happen on Wednesday. But anyways, here's how the stream went. 2 days ago, we covered the Bryan Kohberger hearing that happened. And essentially, the defense was arguing for a delay. We're supposed to have trial somewhere in August. I think they said jury selection might take about 3 weeks. And then the trial opening statements should happen at the end of August. However, the defense, they want to have a delay because they said they are still in the process of working through their mitigation phase. You know, they have experts that they want to interview. And the state criticized them, saying that, well, you could do an investigation into, you know, the defendant's background, but you can't do a scorched earth. That's a phrase that they use, a scorched earth investigation to find every little tidbit about this defendant and whatever it is that you want to investigate into. So there was that. There was also the Dateline episode that came out, and the defense was like, well, we need to figure out where the leak is coming from. We need to investigate into this because the judge did say that they are going to hire a special prosecutor or a special investigator, I forgot which one, to investigate to see where the leak essentially came from. Because the defense says, well, if the leak came from someone from the state's office, if the leak came from someone in law enforcement, when we cross-examine these people, we can try to impeach them. We can try to say that they were already, I don't know, maybe heavily prejudiced. Maybe they were trying to get some fame out of this. Who knows, right? And then there was a third thing as well. I think the defense, again, they've been saying this for a very long time. They said that they got a huge amount of data, you know, a huge amount of discovery with this case. I think they mentioned like 68 terabytes of discovery. A lot of it's videos, a lot of it's like tips coming in about this case. And she essentially said that she hasn't had time to go through everything. Now, there were some criticism about it, I think, during the hearing a couple of days ago where the judge, or I don't know if it was during that hearing, but I remember hearing it at a different hearing possibly, where the judge said that like, hey, you know, I offered to have some people to, you know, for you to maybe like have some people to help you with this case, you know, or maybe like hire some help to look through some of the discovery stuff. But I don't know. I don't know if the defense ever really took up on that. I think the judge thinks that they did it. And so the judge essentially saying that like, hey, like, you know, you had some outs to look through the discovery and you haven't done that. But anyways, I want to jump into the judge's order that was filed a couple days ago. And then also the judge did put in an order about the alternate perpetrators theory, because as we're combing through some of these court documents, the defense, well, they're trying to say that Bryan Kohberger is innocent. Bryan Kohberger did not commit these crimes. A couple of things that they listed about Bryan Kohberger, they're going to talk about his diagnosis, you know, his OCD, and how he is like a very clean person, wouldn't be able to commit these murders maybe because it's like a messy thing possibly, and how when he was like taking out the trash, you know, mysteriously when he was arrested, it wasn't because he was trying to get rid of evidence, you know, at like 1 a.m., 2 a.m. in the morning. It was because he's an person with OCD and he likes to clean things, you know, and it's like obsessive on his mind. He has a hard time falling asleep. That's why he goes out on long drives. And then additionally, they did talk about his diagnosis of, this isn't one that I've never really heard before, coordination. Oh gosh, I'm going to mix up the term here. some sort of like a coordination issue where they said that he wouldn't have the time and the meticulousness to commit these crimes in a very short time period. But again, the state and the judge has pushed back on the defense about that, saying that like, well, your expert said that he suffered maybe more severely when he was younger. It doesn't seem to affect him now that he's older. And it might be more something towards like finer motor skills, right? Not like the gross motor skills, like larger movements and stuff like that. But anyways, I'm very excited to cover this. And I was initially going to do it just a video, but I was like, no, I kind of want to stream this because I kind of miss y'all. You know, I love doing the streaming stuff. So I don't think I streamed last week. We're going to get into the alternate perpetrators theory, and just like it's mostly redacted. So we don't know which individuals Bryan Kohberger and his team are pointing their fingers at. However, we do see a little bit of tidbit here and there, like, you know, these are people that are potentially close to the victims, and there's one individual that was like following the victim around in the mall or something like that. So let's cover this. And honestly, I don't think it should be a really long video. I highlight all the portions that I want to cover. We're not going to read the entire document. We're just going to read the highlighted portions, and then I'm just going to do some commenting, and then we'll get into the other document, which is a lot shorter. So let's get into this. I'm super excited. Man, I can't believe the trial is going to happen soon. It's going to be, yeah, like basically in like 2 months. 2 months. All right. So this is a redacted memorandum decision in order on defendant's motion to continue. So he's going to redact the portion, I think, that discusses, something that the defense found out about Bryan Kohberger, and they wanted to do more investigation about it. And that's why they wanted to delay the trial. We don't know what they found out and what it is they want to get into. That portion has been redacted. And I think it's also redacted for, I don't think it's redacted for the state, not that portion though. All right. Defendant's motion to continue the trial in this matter. The motion is threefold. So first, Bryan Kohberger asserts that the volume of discovery continues to pose a challenge to his counsel's ability to timely and meaningfully review all of it. The judge is going to get through each single one of these, and I would say this is a quite scathing order that is directed towards the defense. Essentially, it's just, if I was the defense reading this, I'd be like, damn, like, I don't know, I might be in tears or something like that. But, you know, I'm sure the defense team, they're used to this. They've been practicing law for a very long time. But yeah, I think it's pretty scathing. Second, he asserts that there is a penalty phase investigation and preparation that still needs to be done. And then third, he asserts that a recent and forthcoming publicity on this case is highly prejudicial. Now, remember, the defense said that, well, there is a Dateline episode about Bryan Kohberger, and, you know, the Dateline episode is very overtly pointing that Bryan Kohberger is guilty. And then additionally, there is a book that's coming out soon by, I think, a known author that does true crime stuff, I think. I feel like I've seen his name before. And then there's also some Amazon TV series or like a teledoc series that's coming out very shortly. So, Oral argument on this motion was held on June 18, 2025, so it was about a week and a half ago, after which the court took the matter under advisement. The court finds that a continuance is not warranted as the defendant has not made a showing that there is good cause to continue the trial or that his substantial rights will be prejudiced by proceeding to trial as scheduled. There was also an ex parte filing that was submitted by the defendant, and the state doesn't have access to this. However, I think there was a redacted version that was given to the state, right? Yes, there was a redacted version that was given to the state. I don't think we were even able to see this filing at all. All right, so under the Idaho law, a criminal defendant seeking a continuance of trial must demonstrate that his or her substantial rights will be prejudiced absent a continuance. And the judge basically says that it's not the case here. Not the case for Bryan Kohberger, right? I feel like James Patterson, but I thought James Patterson wrote like fictional crime books, because I feel like I've seen his name before, especially we have something called little libraries in California, or I don't know if it's just in California, but there's something called little libraries. And essentially you can basically just take the book for free as long as you bring a book back. And I feel like I've seen James Patterson, and I feel like I have a book that I grabbed from the little library, and I felt like it was like a fictional crime book. Oh, are they everywhere? Okay, I wasn't sure if, because I've never seen them in the East Coast before. Never seen them in the East Coast. Never seen them in other states when I visited. I've only seen them in California, specifically near the Los Angeles area. Maybe. Oh, am I mixing with John Grisham? No, I don't think so. I feel like it was a James Patterson book, but maybe I am mixing them all up, possibly. All right, so the defendant argues that continuance is necessary for him to sufficiently review relevant discovery, conduct a full and complete investigation of mitigation evidence, particularly claimed newly reviewed evidence that allegedly raises red flags. So I think this is the ex parte document, and remedy the prejudice caused by recent and upcoming inflammatory publicity and the alleged leak of information to the media. Moving forward with the trial, he warns will violate his rights under the United States and Idaho constitutions to due process, to be free from cruel and unusual punishment, to a fair trial, to effective assistance of counsel, and to present a defense and to confront witnesses, and to a fair and reliable sentencing determination. That was a mouthful. A lot. This is what the judge writes. Absent from the defendant's materials, however, is a good cause for a continuance or legitimate showing of prejudice should the trial proceed as scheduled. So essentially, all the, not excuses, all of the reasons that Ann Taylor gave to the judge, he's basically saying that nothing in here, anything that you said in the filings has not shown that there's good cause for having a continuance in this case. Let's start with A. Defendant has not demonstrated continuance is warranted to review discovery. Again, so this is the first fold. They contend that the vast amount of discovery is impossible for the defense team to review the necessary and relevant discovery. So this is something that we've heard over and over again. This is not the first time that Ann Taylor has raised this issue. She said this multiple times where she said that, hey, we've got this like giant amount of discovery here and we're just like still going through it. I think even as early as like a week and a half ago, she's still saying that she's going through it with her team. So defense is arguing that without any support or explanation, that there are a myriad of issues and continue to arise from the state failing to comply with discovery and expert disclosure deadlines. However, the court does not agree with the defense and said that he rejected this argument 2 months ago when the defendant sought to strike the death penalty and impose the discovery obligations upon the state. The court observed the utter lack of proof supporting defendant's accusation of discovery violations by the state. The court also found the defendant's complaints of being unable to meaningfully review discovery entirely unconvincing, pointing out that counsel struggled to articulate in any meaningful way what evidence, let alone relevant evidence. So I want to comment on this portion right here because remember when we were watching the hearing on June 18th, I was saying that, hey, like, you know, if you really want to convince this judge that you want to have a delay, I feel like you have to be really pointed in your answers. You have to really identify, okay, we're trying to find X, Y, and Z. Here's how we're going to find it. Here's what we're going to do to possibly, you know, make it so we could meet this XYZ deadline. I don't know. I just felt like it was just very unspecific when she was making her arguments. I feel like you have to make really specific arguments to the judge instead of being a little bit vague about it. I know Ann Taylor, you know, she's like, well, I don't know what I'm going to find, right? Because it's so much discovery here. But I just felt like she just had to be really vague, like, hey, like maybe when they were going through, you know, this discovery, it led them to like maybe a possible theory here or like this other thing. I don't know. I just felt like it just didn't feel very specific when she was making her arguments. Maybe it was more specific in the ex parte filing that she'd made or that she submitted to the judge, but I don't know. But it seems like no, because right here, the judge is saying that there was no relevant evidence that the counsel was able to specifically point out to the judge. So this is what he writes. Court found the defendant's complaints of being unable to meaningfully review discovery entirely unconvincing, pointing out that counsel struggled to articulate in any meaningful way what evidence, let alone relevant evidence, counsel had been unable to review over the past 2 years and why efforts to facilitate discovery review were not made long ago through this court and or the resource judge. There's a little footnote here. Defendant continues to complain of the state's discovery violations. But to be clear, this court has found no such violations by the state. Also, this is addressing the terabytes of discovery. Defendant's continued reference to the number of terabytes of discovery produced in this case is not helpful without providing a meaningful explanation of what that data primarily consists of and its particular relevance and importance. Indeed, as it was discussed on April 9, 2025, hearing this case, it appears that most of those terabytes consist of extensive video surveillance from local businesses, residences that show nothing of significance. In fact, the state indicated at that hearing that much of the discovery is completely irrelevant and stipulated that it is unaware of any Brady material in the video surveillance footage other than specifically identified in motion practice. Given that the state has identified all of its trial exhibits, the defendants or the defense cannot be unaware of all incriminating evidence in the discovery. It says cannot be unaware. It's like a double negative. Those like kind of like fuck my brain up sometimes. Finally, it should be noted the defendant, who early on demanded the state provide all investigative materials, no matter how irrelevant and or unhelpful. So the judge is essentially saying that, yeah, it's a lot of discovery that you guys have. However, the state has already combed through it, it seems like, and they've already identified what could have been, you know, possibly exculpatory to Bryan Kohberger, and then what they're planning to use against Bryan Kohberger. But it seems like the defense is the one that wanted to get everything, no matter what, you know, even if it might not be irrelevant, because they probably want to make sure that they can comb through everything. But it's like, you're the one that asked for all this discovery, and yeah, you're the one that has to deal with it. But it seems like the state has already identified what's pertinent and what's not. But I get it. You know, if you're on the defense team, you're not going to rely on the state all the time, because maybe they missed something, you know, maybe they're hiding something. You never know. But now that we know that the extensive discovery, the amount of terabytes of discovery is because it's just a lot of surveillance footage from businesses and like residences. Whew, all right. The court, however, rejected the same argument 2 months ago when they sought to strike the death penalty. Sorry to read this part. Oh, I think I finished this paragraph. I did. All right, next page. Defendant's second round of this argument fares no better. He again fails to identify any relevant discovery that his counsel has yet to review. He also fails to identify any steps his counsel has taken. See, this is the part too that I think is also very important for the defense to point out to the judge, right? It's like, hey, like we have so much shit to review, but here are the steps that I've taken so far to review it. And still, it's really like tough. It's really hard to. I think the judge, again, like I said, the judge said that like, hey, like if you need more people to review some shit, like hire more people. And I think the court was pointing out that like, oh, it seems like you did hire people, but maybe you need to hire even more people to do some of the, I don't know, go to the discovery and all that stuff. Hey, how are you doing today? Hello. How's it going? Yeah, I was actually watching News Nation today, and there were some new tidbits of information that came out of that. Maybe I'll watch some portion of it with you guys. But the News Nation, I think her name is Ashley. She was talking to, I think one of the victim's father. And essentially, I'm trying to remember what they revealed that was kind of new. The father mentioned that his daughter had a broken nose because he believes that the friend was targeted first, and then the daughter woke up while the friend was being attacked, and then she tried fighting back, and then the father said that like she like suffered like a broken nose because she was like probably hit in the face multiple times, and then yes, so I remember hearing about the phone call to his father that Bryan Kohberger made. The phone call to his father. Oh, it was Bryan Kohberger calling off work that same day, which I've never seen any of the court documents so far. So I felt like we learned like some little tidbits of information, and then we'll see when the trial happens to see if they're true or not. And yes, the knife hasn't been recovered yet. Knife has not been recovered yet. However, Bryan Kohberger's DNA was found on the knife sheath that was left at the crime scene, but they still have not found the knife yet. Why didn't he just fly home for Christmas? No need to drive back. I don't know. I'm not quite sure. Yeah, why make the cross-country trip back with the car? I don't know. That's a lot. I thought he was just heading home for the holidays. Wasn't school over? I don't know if he had another episode. I don't know if he had another semester to do for his school. Maybe. I'm assuming yes. But it would be kind of, because I would assume that like, well, you're taking a car and then you're driving cross country all the way from Washington to Pennsylvania. Like that is quite a trek. The gas for that, you're adding more mileage. And then you also have to drive the car back to Washington as well, assuming that he has another semester at the school. But I don't know. Maybe they just wanted to do a family road trip thing. Maybe it's fun for them. I don't know. To me, it just seems really inefficient and just not fun. Hire more paralegals. Enough with the delays already. Well, the judge did say that he is not going to let there to be a delay. They're going to have the trial as scheduled. I was watching Crime Talk, and he said that Anne gets paid $200 an hour at 40 hours a week. 4 weeks a month, she's making $32,000 a month at those paychecks. I want it to be delayed longer too. You can actually look up to see how much she's paid, because I think it should all be public because she's a public defender. You can see like a pay range of what she gets. I'm sure him calling into work is completely new info. Yeah, right, because I haven't seen it anywhere else, but we could watch that portion of the interview together. Maybe he's scared to fly, possibly. I don't know how he went from Pennsylvania to Washington the first go around. It could have been the same thing. He could have just drove cross country. That's a possibility. All right. So Here's what the judge says. Defendant's second round of argument fares no better. He again fails to identify any relevant discovery that his counsel has yet to review. Did I already read this? Oh, I should just leave my mouse pointer where I left off. I'll just read it again. He fails to identify any steps that counsel has taken, particularly since the court's prior order, to aid in processing the yet unreviewed discovery. He does not explain why he waited to seek a continuance after the discovery closed. So they had a discovery deadline. That discovery deadline has been closed, but they're like, well, after the discovery deadline has been closed, why didn't you, prior to that date, why didn't you ask for a continuance then? Why are you doing it after? Expert disclosure deadline passed and the pretrial conference occurred. If defense counsel was truly struggling with discovery review, so again, it seems like the judge is not buying it, that they are struggling with the defense, the defense counsel is having a tough time sifting through all the data, I guess. This motion should have been made when the claim problem became apparent, and certainly should have been brought prior to the expiration of discovery. I will say in the defense's defense, I did hear her talk about this multiple times through other motions that they were filing, and she was making arguments to the court saying, like, oh, there's so much data, like, we're still going through all this. Again, expert deadlines, the final pretrial conference. Instead, defense counsel has robustly litigated this case. They retain approximately 24 experts, a full mitigation team, engaging in extensive motion practice, and disclosing witness and exhibits list with nary a whisper. That's a word you really see, nary a whisper, that a continuance should be sought. These actions belie his counsel's ongoing and ultimately empty discovery complaints. I'm telling you, to me, like, even though it's not, the language here is very formal, to me, this sounds very scathing to the defense. The court can only conclude the defense counsel is using the volume discovery measured in terabytes as a tactic to delay the proceeding at the 11th hour simply for the sake of delay rather than a legitimate threat of prejudice to the defendant's substantial rights. See, that's pretty fucking scathing right there, in my opinion. Also, he points out the utter failure of defense counsel now or at any time to specify not only what needs to be reviewed, but importantly, when that review would be complete and the defendant ready for trial. Again, like I was mentioning before in the other hearing, I feel like they have to be really specific about what it is they need to review, what it is that they're trying to get out of that. And then, I don't know, maybe identify like, okay, like here's what we're planning to do to alleviate this. And we're hoping to do it by this date. But I just felt like her arguments was just very vague. But I do like her, though. I do like Ann Taylor. I don't have any issues with her. Instead, defendant seeks an unbounded continuance with no apparent plan to complete the review of unspecified evidence that counsel claims it has yet to review. Next, B. Defendant has not established a continuance is necessary to conduct a more thorough life history investigation and identify necessary experts. So here's where we're going to start getting the redactions here. I'm going to try my best to read the redactions, but honestly, I guess we should try not to speculate too much, but I do have one tiny teensy little speculation, and I'll share with you guys probably like towards the end, maybe, when we get into more of it. All right. Defendant next argues it needs additional time to investigate and prepare mitigation evidence, which he contends is necessary to uphold his constitutional rights, particularly under the 8th and 6th Amendments. We got some redacted here. Despite having hired a mitigation team 2 years ago, the defense counsel contends that recently discovered, redacted, has raised red flags that the defendant may have, lots of redactions here. According to the defendant's primary mitigation investigator, attorney, redacted, her team of 4 have been diligent in their investigation into defendant's life history, but there has been omega redaction. She believes that with time, she'll be able to overcome these barriers by redacted. Ex parte declaration. So this is from the ex parte document, which we don't have access to, and I believe the state has a redacted portion of that. So I don't know. I don't know if they were trying to... I mean, it seems like they were going through Bryan Kohberger's life history, and then they could have uncovered something, maybe something about his family or his family tree that could be relevant to this case, and maybe why Bryan Kohberger's the way he is. I don't know. That's my speculation. We don't really have too much here, but we do get some more redactions below. The judge is over it. Yeah, I feel like you can see it in my thumbnail, right? Where we have the defense making their arguments and the judge is kind of sitting there like this. And I'm just like, oh man, that's like the body posture that I would not want to see in someone that I'm trying to convince at that time. That would make me even more nervous. The Eighth Amendment requires that capital defendant be allowed to present all relevant evidence in mitigation. However, the judge is arguing, same thing with the state, saying that like, yeah, you're allowed to present all the relevant evidence, but that doesn't mean you have to present everything about Bryan Kohberger. And again, they talked about the scorched earth investigation. The assertion that counsel needs continuance to conduct an exhaustive and comprehensive dive into defendant's life history for additional mitigation evidence overstates the extent of his counsel's constitutional obligation. So again, I mean, it makes sense, right? The defense, they want to go above and beyond, and the state and the judge are saying that, well, you don't really need to go over everything, right? We don't need to include everything about Bryan Kohberger's, his tidbits of his life and stuff like that. The Idaho Supreme Court and the United States Supreme Court hold that defense counsel is not required to investigate defendant's entire life in order to present constitutionally sufficient mitigation evidence. Hey, Shanzo, how are you doing today? Yes, over the weekend, yeah, crazy stuff happening in Idaho. So fucked up. So there was this guy who, I guess this is, I think we're still waiting for more information to come out. But from what I've seen so far, there is a guy who started a fire to lure a fire department over to extinguish the fire. And as they arrive to do their job, it's a fucking emergency. He starts shooting at them. It's like the sniper. I don't know. And I heard that he was like a 20-year-old guy. Like, I don't know, fucking crazy. What a piece of shit and coward you would have to be to attack emergency response people who are just doing their job. I don't know. I wonder if he just had some sort of like really weird grudge towards firefighters. But I think, wasn't he also trying to target just people that were just like there as well? Exactly. That's so weird. Fire department. I don't know. The only thing I've seen so far is they identified him as like a 20-year-old person. Fucking piece of shit. All right. The Idaho Supreme Court and the United States Supreme Court has held that defense counsel is not required to investigate the defendant's entire life in order to present constitutionally sufficient mitigation evidence. All right. So they're talking about Roe, a capital case that is instructive here. Did I want to read it? On post-conviction, Roe argued her counsel was deficient because they failed to perform an adequate investigation to Roe's background in the search of mitigating evidence. Specifically, Roe argued that counsel should have investigated her life from birth to sentencing hearing, and that counsel were deficient in presenting her mental health workup. The court rejected this claim, holding that counsel was not required to investigate Roe's entire life in order to objectively and reasonably present Roe's mitigation evidence. Now, here are some of the people that are going to... Oh, no, never mind. I was confusing this list with a different list. There was a list of people that they were planning on having to testify in the trial. Actually, some of the people might be in here. So here's what we have so far with the investigation into Bryan Kohberger. Also, people that knew him, the traumas that he dealt with, awesome, a bunch of other stuff. So here's what we got. Defendants K, PhD, education records, including coursework, interviews, and correspondence. Bryan Kohberger's mental health and medical records, including redacted. So maybe that's part of the ex parte thing that was mentioned earlier. Records related to a childhood car accident, which I feel like I remember speaking about this with you guys. The childhood car accident, or was I just thinking in my head and I just thought I said it to you guys? So again, it seems like there was a car accident that happened to him and it was really traumatic for him. We go through Bryan Kohberger's employment records, his mental health, his education, employment records of his sisters as well. I don't know if defendant's sisters. Oh, for some reason, I thought he only had one sibling. It seems like he might have two sisters at a minimum. Mental health record of the defendant's parents as well. So this is what I'm starting to think that, like, okay, maybe it's like some sort of a generational thing. Maybe something runs in his family, right? Maybe some sort of mental illness or disease runs in his family. That's why they're really getting to, like, the father's side of the family, because it says here, father's military records and social security records, court records from multiple generations of the Kohberger family, paternal side only though, so only focusing on the father's side. VA records and death certificate from maternal and paternal uncles, so mom and dad's side, multiple interviews with the defendant and each family members, interviews of two. So this part was kind of interesting. So they interviewed two of Bryan Kohberger's fourth grade teachers. So I wonder if something happened in class with one fourth grade teacher, and then maybe it was so traumatizing he had to be transferred to a different class or maybe a different school with another fourth grade teacher. Because why would you have two fourth grade teachers? Or maybe it has nothing to do with what I'm saying right now. Who is Bryan Kohberger? Bryan Kohberger is the one who's accused of murdering the 4 students in Idaho. This was back in, was it 2022? Jesus, I think 2022, right? They also interviewed Bryan Kohberger's former boxing coach, the psychologist who evaluated Bryan Kohberger in 2005. So Bryan Kohberger is younger than me. So 2005, he would have been, how old would he have been? Like 8, 9? No, he's like significantly younger than I am, right? 5, 6, 7? What's his birth date again? Was he born in 1994? I don't know why, but 1994 is like in my mind right now. 8, 7? Maybe he murdered his 4th grade teacher. If he murdered his 4th grade teacher, how would they interview the 4th grade teacher now then? Bizpo? The 4th grade teacher probably told him no for the first time in his life. Recovery Addict says breaking news: BK takes a plea deal. They say that he's innocent. They say, I don't know. I've only heard the defense say that he's innocent, but yeah, link it in the Discord for me. I think 4th grade is where we started splitting up from different homerooms and we were put in different math classes and stuff. I think it depends on where your school is, but for us, that was 1st grade. Yeah, 1st grade was when kindergarten is where you would have all your classes in one, and then 1st grade is when you start having like an art class, PE. I think math was still with the same teacher. I think math they started splitting up for, at least for me. No, I think math we were split up in like 1st grade too. Really? I believe they're going for insanity plea. Oh, interesting. Yeah, if there's any developments or anything, just post it in my Discord if you guys are in my Discord. All right. So they also interviewed multiple members of the defendant's extended family on maternal. Oh, okay, so maternal and paternal side. Interviews with defendant's professor and advisor at DeSales University. Interviews of defendant's former co-worker. Interviews of at least one family friend, and letters and jail calls between the defendant and his family. I wonder if we're going to see the letters and if we're going to listen to the jail calls during the trial. Really? Brian Denton, I've learned Bryan Kohberger has accepted a plea deal. Sources confirm the prosecution has proposed dropping the death penalty in exchange for Kohberger pleading guilty to committing the 4 murders and serving life. All right, well, let's go back to this. It is evident from the reports of defendant's mitigation experts, Dr. Orr, Dr. Ryan, Dr. Brams, that they have developed an expansive understanding of the defendant's family, environment, social development history, family history, educational history, mental history, and mental health and medical history. You know what? Sorry. I wonder if, because we're going to get to the next part soon where the ultimate perpetrators theory, where the judge is going to address that. So I wonder if maybe that was like the last straw for them. Like, hey, like, let's try to get in the ultimate perpetrators theory. You know, it could have been 4 other people that done this. And because the judge essentially denied that, if they're like, oof, okay, Bryan Kohberger, this is not looking good. All right. Your DNA is on the knife sheath. We got the purchases. We got the receipts. We got some, you know, like there's like 1 or 2 eyewitnesses, maybe the DoorDash driver, maybe the surviving roommate. I don't know. I just wonder if I don't know, maybe that was the last straw, the ultimate perpetrators thing being denied. But let me get that soon. Wow. Crazy. Despite the extensive investigation, defendant claims additional investigation is warranted to identify 1, redacted, and 2, redacted, which we don't have. Rather, the claim need is based on unqualified speculation by redacted. Defendant has not offered any declaration by any of his disclosed mitigation experts, opining the same, nor has he pointed to any other expert reports that would support redacted speculation. So it seems like one person has a speculation about Bryan Kohberger and maybe his history, and the judge is essentially saying that, well, you know, he's been evaluated by 2, 3 other experts and no one else supports the speculation. I wish I knew what this was. As noted, a continuance of trial is not warranted to chase down mere speculation that potential evidence exists. Further, defendant has not set forth a plan for continued investigation, how much time it will take, and what his team expects the investigation will reveal, why it is necessary to uphold his constitutional rights, and why these matters are only now being raised with the court. Additionally, assuming guilt is found, the penalty phase of the case will not begin until late October or early November. Thus, there remains significant time for Redacted and her team to continue their investigation and to supplement expert disclosures if warranted. So again, some sort of speculation about Bryan Kohberger, maybe something about his past, his history, his family, and they want to investigate this more. We don't know what it is because it's all been redacted, but let's read and see what we can maybe get out of it. 1. Redacted speculation that the defendant, redacted, is simply that, speculation built on circumstantial evidence. A bunch of redacted shit here. Conditions which are currently attributed by his own mitigation experts as to ASD, autism spectrum disorder, OCD, and then ADHD, are consistent with childhood trauma. And 5, there is evidence of poverty, both generational and familial. According to Omega redacted. Notably missing from redacted declaration is any indication as to how she intends to confirm her suspicions or how long she expects to take, be that months, years, or even decades. Defendant has been subject to multiple lengthy interviews by several different experts over the past 2 years. Based on the expert reports reviewed by this court, redacted, defendant's family has likewise been extensively interviewed, and there has, a bunch of redactions here, been no report that, redacted, none of the defendants, redacted, have raised alarm that, redacted, despite having the same information, redacted, relies upon. Instead, it is an invitation for perpetual continuance. More importantly, aside from the redacted, all this information has been available and documented in the record for months. Yet again, that defendant is only moving for continuance for further investigation into redacted, unsupported suspicion smacks of tactical gamesmanship and delay. Absent more compelling evidence that redacted plan for... Let's see what we can get in here. All this is redacted here. It's unreasonable for the court to continue the trial indefinitely for redactions. A plan that is temporally unbound, substantially undefined, and unlikely to result in any relevant mitigation evidence in the foreseeable future. Lots of redaction here. I'm going to have the news on and watch for the breaking news. Yeah, on national news if he takes a plea deal. I mean, it seems like one person got the wind of it, and then maybe, you know, everyone else is like, oh my God, what's going on? What's going on here? So, and they're just ironing maybe some details out. We'll see. That would be crazy, though, if this ends up being like fake news or something. But, you know, I think Bryan Enton, pretty... I followed him for some other stuff as well. I think... didn't he also cover Vallow and Daybell as well? Because I feel like I've definitely seen his name on other cases. I read the defense is bringing witnesses from Pennsylvania to take on the stand. Oh, yes. Pennsylvania as well. Yes. Court TV was about Diddy. Okay, yeah, guys. Have your eyes and ears out. Let me know if you guys see any more news and development about this plea deal. Thank you. I appreciate you guys sharing with me. 2, redactions. Counsel's argument that more time is needed to investigate whether redacted, likely squarely unsupported. Defendant has never moved for an extension for his disclosure deadline for penalty phase experts so as to allow further opinions in this regard. Nevertheless, redacted, who again is not even marginally qualified to opine, redacted, believes that there's evidence that redacted and seeks additional time to unearth it. Her support, which has not been provided to the court. Again, same thing it seems like there's an expert, someone out there that thinks that there's something to uncover about Bryan Kohberger, and it's speculation, and the court's like, I don't even know if this is even going to go anywhere. So all this has been redacted. We don't know what it is. Not only there's a lack of support and record for redacted's anticipation that more investigation into redacted to change their minds, redacted, and her team of defense counsel have known since November 2024. So this right here I thought was kind of important because it seems like the judge is saying, well, this is something that you had a tip about back in November 2024, and you're only bringing this up now? Neither the defense nor redacted have articulated what efforts they have made, if any, since that time to understand the basis of redacted. Further, they have not indicated what plan they have to obtain this information, if a continuance is granted, or how long it would take. All redacted here. Breaking news on the TV news. He did plead guilty to all 4 deaths. Wow. Are we going to get that hearing? We need the footage. I want the footage. That's wild. You know what? I'm happy for the victims and their families. I feel like, I mean, I don't know if maybe they really wanted to push for DP, but I mean, to not have to go to court, sit there, testify, watch testimony, because it's what, 2 to 3 months long? I don't know. It could be good for them. And then to have this person say, hey, like I did it. But I don't know. I hope it's good news for the families. I wonder how they're taking it. Defendant has not demonstrated that a continuance or further investigation to potential mitigation evidence is necessary to uphold his constitutional rights. The right to present mitigation evidence and the right to effective counsel do not necessitate an investigation to his, again, entire life history. They simply require the investigation be reasonable. Further, the evidence prompting the need for further investigation has, redacted, been available for months. Yet it is only now the defendant seeks a continuance. This tactic seems geared towards achieving delay rather than a good faith effort to obtain meaningful mitigation evidence. Again, they're talking about a fishing expedition, pulling at every conceivable thread in defendant's familial tapestry. So I wonder what is it about Bryan Kohberger's family history that is, you know, kind of like alarming to the defendant expert. C, continuance not warranted due to pretrial publicity. So again, May 9, 2025. Wait, one in chat if you guys Did you guys see the Dateline episode? 1 in chat if you saw the Dateline episode. 2 if you didn't. Leads were in Fox News. All right, let's go to Fox News. Is it like Fox 25 or is it like the Fox News? Which Fox News is it? Many of Bryan Kohberger's defense witnesses don't want to go to Idaho to testify at the upcoming murder trial, including his former boxing coach, who told the Pennsylvania judge the suspect killer never competed and just came to work out. Jesse Harris, a boxing gym owner and contractor who Kohberger claimed to have studied under as a teen, this is back when he was a teenager, asked the Pennsylvania judge to block a subpoena on the case based on undue hardship and the fact that it's been almost 15 years since he saw the 30-year-old Kohberger. Harris says his wife is fighting cancer and he can't step away from his business for 20 minutes, let alone the time it would take to travel to and from Boise. It seems like Bryan Kohberger's father brought him to the gym to build up his confidence when he was 15. He described the operation as a place for kids to go when they couldn't make the cut on other sports team. He said Bryan Kohberger never competed. He just worked out. Oh, that's him. Kohberger never even sparred there, he said, although the suspected killer wrote on the job application obtained by Fox News Digital that he boxed every day after school at the Jesse Harris boxing gym. Jesus. Hour-long hearing on Monday on whether or not half a dozen Pennsylvanians should be compelled to travel to Boise for the trial. Only one agreed to go on his own. That was Anthony Soma, a former classmate of Kohberger's. Other defense witnesses were told to return to court next week. And hours after the hearing, the court revealed that more witnesses could have been subpoenaed or have been subpoenaed by the prosecution. Ackerman. Okay, so court raised the chief of police at Pleasant Valley School District, where Kohberger once worked as a security guard before he was forced to resign for undisclosed reasons, according to public records. Interesting. Ackerman's connection to Kohberger was not immediately clear. Kohberger's defense has already reserved a block of hotel rooms for his witnesses and is responsible for the cost of airfare and lodgings. Brandon also asked the judge to deny his subpoena. It was a losing effect. He said he's a new father and provides a sole income for his family. Reports that the Kohberger's 2 sisters lost their jobs due to the connection to the quadruple murder. Okay, so he does have 2 sisters. A suspect have him worried that he could lose his livelihood next. The judge upheld the subpoena. Andriola asked if he could testify remotely, and the judge said that would be up to his counterpart overseeing the trial in Idaho, Judge Stephen Hippler. Ralph Vecchio III appeared in court in response to the subpoena for Ralph Vecchio. He said his intended recipient may have been his father, who owned the family car business back in 2019 when Kohberger's parents bought a white Hyundai Elantra. The younger Vecchio took over in 2021. He said he never met Bryan Kohberger. Then there was a jail guard who preserved Bryan Kohberger's records for a brief stay in Pennsylvania lockup before his extradition. Will likely not appear. But Kohberger's attorneys need to subpoena those records themselves and not the correction officers who maintains them. Okay, so he's supposed to come back to court next week. Yeah, I saw Brian Enton said it on X. I have that. I'm on Fox News right now. I don't see it on Fox News. That's why I was like, is it Fox 25? Is it Fox 35? Well, like, which Fox is it? Which one? Where are we at? Oh, man, because I don't want to update my title say like, oh, Bryan Kohberger took a plea deal, and then it's like not even true, you know? Ann Parham, an advisor at Kohberger's former high school, was ordered to testify before Monday's hearing and will be present at trial. Okay, here's what we got. Former boxing coach says Kohberger never competed despite suspects' boast. Jesus, that headline. Many of Kohberger's defense witnesses don't want to go to Idaho to testify. Okay, this is like basically the same thing. Yeah, this is the same article. Okay, I'm on Fox News. I'm on Fox News right now. I typed in Bryan Kohberger. Oh, here it is. Okay, bombshell. Breaking. We're here, guys. Check Discord. Okay, let me know if there's another...
Defense for Bryan Kohberger just suffered a huge legal blow, and it could...
Oh, this is old video. News Nation. All right, we'll hop to News Nation next. Idaho student murder suspect Bryan Kohberger has accepted a plea deal to spare his life in exchange for a guilty plea in the murders of the 4 University of Idaho students. 2 sources close to the case with Fox News Digital Monday. I guess I could update my title now. I mean, I still want to cover the rest. I guess there's no point, right? There's no point in covering the rest of the court documents. I was looking forward to covering it. I should have streamed earlier. This is crazy. Kohberger 30 is accused of killing Madison Mogan, 21. Kaylee Gonzalez, also 21. Xana Kernoodle, 20. Ethan Chapin, also 20. In a 4 a.m. home invasion attack on November 13th, 2022. Where are the Kohbergers now? I don't know. That's what they were trying to summon them on X. All 4 had been stabbed multiple times with a large knife. Police recovered a K-bar sheath that they allege had Kohberger's DNA on it near Mogan's body. News Nation just learned that the accused killer, Bryan Kohberger, accepted a plea deal. Yeah, plea deal was offered. He accepted the deal. Sources are confirming the prosecutors proposed dropping the death penalty. That was the deal in exchange for Kohberger. They're pleading guilty to committing 4 murders and pleading guilty to burglary as well. So guilty plea in exchange for no death penalty. Now, the background in the story, you'll remember he's accused of killing these 4 University of Idaho students at their home back in November 2022. Sources say Kohberger must also agree to spend the rest of his life in prison without any possibility of parole. So jail for life, no parole, but again, no death penalty. That's been waived. His right to appeal is part of this as well. Plea deal has been accepted. Okay, so he can't even appeal this, right? So he waived, there's no parole, jail for life, and can't appeal this. Plea deal has been accepted. A court hearing of change of will take place on Wednesday. So in 2 days. Okay, court hearing for exchange. Jesus. Okay, 2 days. We'll listen to it. I wonder what's the term again? The straw that broke the camel's back. Well, okay. Can we still read the alternate perpetrators thing then? So essentially, we already know that the judges had already denied the continuance. Denies the continuance, says that who cares that the Date Night episode came out? Who cares that there's an author that's writing this book coming out? Who cares there's an Amazon Prime Video 4-part docuseries that's coming out, right? He believes that they're able to find a jury that's going to be impartial and to weigh the evidence in court and make their decision. Also, they've had some high-profile cases here in Idaho before. Again, probably looking at Vallow and Daybell. Also arguing that there's no assurance that the pretrial publicity will fade over time. The murders occurred over 2.5 years ago. The circumstances of the murders were provocative. 4 college students in small Idaho college town were brutally stabbed by an unknown perpetrator. It is immediate media sensation, garnered widespread attention, and that not only continues to persist, but continues to grow. 18 months ago, the defendant moved for a change of venue from Latah County due to the part of the extensive inflammatory pretrial publicity. Allegations made about Mr. Kohberger to the public by media that will be inadmissible at trial. The motion for the change of venue. He argued that Latah County was not large enough to avoid the bias caused by the pervasive prejudicial publicity, and so they granted that motion, and the trial was continued by 10 weeks, they said. And so the judge says, well, even though we delayed the trial by 10 weeks, it has not faded the media attention. It has only given the media more time and opportunity to provide coverage to public audience, which is clamoring for answers. The longer the public is made to sit and wait for the facts to come out at a trial, the more time there is for inflammatory, speculative stories, movies, books to circulate, and more time for prior ones to be rebroadcast, purchased, viewed, and consumed by the public. Continues not warranted to investigate the leaked information. So again, the judge is saying here that, well, we don't know who leaked information. We can't make assumptions that the leak came from law enforcement or it came from the state's office or the prosecution's office, and that we're not going to hold this court and wait for the leaker to, be announced. So I wonder if do you guys think now that Bryan Kohberger took the plea deal, do you think, no, they should probably still investigate the leak, right? Because what if the leak is in law enforcement? What if the leak is from someone in the prosecution's office? You would still want to know. So, the person who leaked it, I don't think you're going to be like, oh, phew, I think I'm good now. No. I think they're going to still come after you. So better watch out. All right. So maybe this is what broke what made the defense really say, hey, well, I don't know, actually, because I guess it depends on how good or how convincing of an argument the defense thought they could make with the alternate perpetrators. So let's jump into this right here. So here's what happened so far. The judge said, we're not delaying the trial. The judge says that we're not going to allow the defense to offer alternate perpetrators, right? That happened recently. And then today they had a hearing about witnesses that did or didn't want to come and testify at the court. Some of these witnesses were people that knew Bryan Kohberger over 10, 15 years ago, maybe more than that. There was 2 4th grade teachers. There was a boxing coach that he had when he was in high school. There was a guy that sold the Hyundai Elantra to his family. So these people are hey, some of them are in Pennsylvania, and we don't want to fly over from Pennsylvania to, fucking all the way to Boise to testify at this trial. And I get it. That's cross country. It's not just you're going an hour or 2 hour drive. It's you're gonna have to fly across the country, maybe get a hotel and all that stuff. So they came in, they told the judge, hey, we don't want to testify, and the judge was okay, we're gonna have you testify anyway. So I don't know if maybe if the defense was already kind of entertaining the plea deal, or if something happened more recently, they're like, hey, like I think a plea deal is really in your best interests right now. Wow. What if Kohberger's own people had leaked it to take the trial? Oh, I don't know. I actually didn't even think about that. That'd be really fucked up. And yeah, I don't know. I just feel like the vibes that I get, even though it's very limited interaction, and it's not even interaction at all because I'm watching them on stream. But Ann Taylor doesn't seem like the type of person to do that. I don't know. She seems like a good, honest person. And they hired 2 people recently that it seems like I don't know. They seem like fine people as well. I didn't get any like shady vibes from them. And they haven't really been in the forefront of the media, I guess. But I don't get any weird vibes from Ann Taylor. She seems like a good, defense attorney. All right, so defendant files his offers of proof and evidence in support, identifying 4 individuals as potential alternate perpetrators. That's crazy, man. It's like, isn't it so wild? Like, if you knew that you did it, you fucking knew you did it because you were there, right? But then it's like, oh, you're going to have your defense team tarnish the names of other people that could have potentially done it. And even though, even if there's not hardcore evidence that proves those 4 individuals did it, like, you never know what happens when things are on social media, in the media and stuff like that. Like there are people out there that could still believe it. That's crazy. I mean, but this is how it is, that's just how they do things in trial. But crazy. So they pointed to 4 other individuals, and it's a good thing this is redacted because we're not going to see who those 4 individuals are, but we do get some little details about who they're trying to point their fingers at. The state objects to the presentation of evidence at trial, arguing it fails to satisfy the standard under State v. Meister. Defendant conceded an oral argument that at this point his proffer is not sufficient to pursue an alternate perpetrator theory at the outset of trial, but requests latitude in cross-examination of the state's witnesses to establish additional evidence to satisfy the Meister standard. So my assumption was that the defense was just trying to, okay, well, even though we didn't meet this threshold that would be able to point to alternate perpetrators, at least let us cross-examine our witnesses or the state's witnesses. For example, probably cross-examining law enforcement, right? Like saying, hey, this person came up in your investigation. Why didn't you investigate them? Why didn't you swab them from DNA? Why didn't you do X, Y, and Z? So my theory is that they were just trying to go after the witnesses and just basically poke holes in their investigation, which is, I think it's a pretty decent strategy. Because sometimes, hindsight is 20/20. Sometimes you're like, oh, well, they should have done this. They should have investigated this. They should have looked into this person. But during the time of the investigation, it's possible that sometimes also that, investigators could also have like tunnel vision as well. Like, oh, I think this person did it, and I'm only going to tunnel on this one person. So I think that's probably what the defense was planning on doing during trial. The court concludes that this time defendant's alternate perpetrator proffer is inadmissible under Meister as it is irrelevant and excluded by IRE 403. That's the rules of evidence. However, this does not foreclose the defendant from cross-examining law enforcement regarding the reasonableness of his investigation and his follow-up on plausible leads. So again, like, in the Karen Reed trial, the defense did a really good job at picking through the investigation. And it's like what they did, what they didn't do mostly, or even if they did do it, it's like how they did it and how things weren't logged and how there weren't reports. So I think that really resonated with trial 2 jurors. Analysis. The seminal Idaho case on the admissibility of alternate perpetrator evidence is Meister Supra. Meister clarified that the Idaho rules of evidence, rather than the more onerous Larson standard, so onerous is was burdensome, hard, difficult maybe, control alternate perpetrator evidence admissibility. I think that's what it means. Onerous, burdensome, heavy, inconvenient, troublesome. Okay, well, along the lines of that. Random donation. Oh, thank you so much for the random donation. I appreciate it. More toys for Shiro. Yeah, more toys and snackies for Shiro. And then we also got a second dog as well. His name is Remy, although we were kind of wavering a little bit on what to name him, but I think we settled on Remy. I really wanted to name him Hannibal, but not everyone has my enthusiasm for horror movies and scary people. But I'm telling you, if I get another dog sometime in the future, I'm definitely naming him Hannibal because I think it's such a cute, fucking adorable name. Anyways, like how funny would it be to have a Pomeranian named Hannibal, like a little tiny dog named Hannibal? Like, anyways, back to this. Yes, we got a Corey. I post pictures of him in the Discord. He looks like a wild little gremlin. Like, honestly, have you guys ever seen the Gremlin movie? I was gonna name him like Gizmo because Gizmo would be a really cute name, or just name him Gremlin. But he also reminds me of Stitch because Stitch has this whole how like in the movie of Stitch in the beginning he goes crazy and destroys a fucking laboratory. Yeah, I was like, we should name him 66. It'd be so funny. You're thinking of Hannibal Barca. I don't know who that is. I only know Hannibal Lecter. There are other people named Hannibal. Hi, Sharkfin Bite. How are you doing today? How's it going? But we had a bunch of like a whole list of names that I thought would have been really cute, but we're trying to see what fits him the most, I guess. Frankie would have been really cute too. Like Frank. Oh my God, that would have been such a cute name. Under these rules of evidence, if necessary, of any tendency to make the existence of any fact of that in consequence is the determination of the action more probable or less probable than it would be without evidence. A sentence like this would hurt my brain in test taking. Oh my gosh. So again, Idaho Rule of Evidence 403, I think what they're really focusing on is confusing the issues. So I think they're trying to say, confusing the issues and maybe misleading the jury. So essentially, if the defense were going to bring up the 4 alternate perpetrators, right, and there's no like good evidence linking them really to the crime scene, then it could just be a waste of time, and it could just be a waste of the jury's, when they're making the deliberation, and also for the state as well when they're trying to counter what the defense is trying to do in the trial. Here, the evidence defendant has proffered purporting to establish the 4 individuals as alternate perpetrators abjectly fails to meet the Meester standard. So abjectly is kind of like a word intensifier for words that are like bad, like abject failure, abject disaster. Namely, the evidence is entirely irrelevant. Nothing links these individuals to the homicides or otherwise gives rise to a reasonable inference that have committed the crime. Indeed, it would take nothing short of rank speculation by the jury to make such a finding. 3 of the individuals, so again, 3 of them, were socially connected to one or more of the victims, interacted with one or more of the victims as a social event in the hours prior to the homicide. So I wonder if they're going to point their fingers at maybe, the way that it's worded, I'm assuming not the roommates, because I know that was a theory that was floating on the internet for a bit, that like, maybe it was the roommates were involved into this, right? But this to me seems like maybe it was like 3 other college students that were hanging out with the victims at a party like before the homicides took place. There's huge redaction here, which we don't have access to. Lived within walking distance of the crime scene, were familiar with the layout of the victims' homes from prior social events, so probably pointing at another friend possibly, or a friend of a friend, while perhaps this evidence could suggest an opportunity to commit the crimes, which no doubt is an opportunity shared by dozens of other victims in the victim's social circle. There is no compelling evidence that any of them had motive to kill the victims, much less physically harm them or a means to do so. Further, there is no evidence connecting them to a crime scene. They have cooperated with law enforcement, provided DNA samples, fingerprints, allowing searches as requested. So it's a good thing they cooperated with law enforcement. It seems like law enforcement really did their diligence in investigating these people, I'm assuming. Seems like it from what the judge is saying. Notably, lab testing has excluded their DNA from samples taken from the crime scene and victims. Here's the 4th individual. The 4th individual did not know the victims, but had a passing connection to one of them while noticing her shopping at a store approximately 5 weeks prior to the homicides. Isn't this crazy? So I think that's how extensively they really looked into, they really investigated this. They were going through all the surveillance footage. They were trying to figure out where the victims were prior and where, if it was like a random person that saw them somewhere and was like, hey, they decided to like go after them or follow them home at some point. It's crazy. They went as far back as 5 weeks prior to the homicide where one of the victims was at a store shopping. So they had to get surveyed. That's probably why there's so much, terabytes of surveillance footage, right? That Ann Taylor was complaining about. He followed her briefly out of the exit of the store while considering approaching her to talk. So this could sound creepy, but at the same time could also not really sound creepy. It could just be like, hey, you saw someone shopping, you thought they were cute, and you were gonna like hit them up for their number. Because even though it sounds like, you're following someone out of the store, it might sound creepy, but because they didn't continually follow her throughout the mall or wherever this was, it probably just seemed like they wanted to maybe approach her and was like, oh, never mind, I'm too nervous to do it. He turned away before ever speaking to her. The event was captured on a surveillance camera. This individual subsequently cooperated with law enforcement, providing his phone number and DNA sample. As with the other alleged alternate perpetrators, lab reports excluded his DNA from the samples taken from the crime scene and victims, that there's no evidence connecting him to the crime scene. We're almost done here, by the way. Collectively, hopefully by the time I'm done reading this article, maybe there'll be more information about the plea deal. But again, it seems like we might have to wait until Wednesday's hearing about the plea deal. And yeah, I don't know. We'll have to wait till Wednesday. I don't know what time yet, though. Let's see what time they are going to schedule the hearing. And hopefully it's open to the public. Collectively, defendants proffer with regards to the four individuals failed to give rise to give an inference that even though that they committed the crimes or otherwise make it more or less likely the defendant was a perpetrator. Therefore, it is irrelevant under IRE 401. Defendant has provided no probative, admissible, significant evidence of motive, ill feelings, means, presence at the scene, or any other connection to the crime that could possibly move the ball to the extent it supports an alternate perpetrator theory. At best, defendant's offer of proof can give rise to only wild speculation that is possible that any of the four individuals have committed the crimes, which is inadequate under Meester. So, I mean, it seems like to me that the defense, they were just losing motions after motions after motions after motions, and then I didn't really watch a lot of the hearings with Judge, but Judge Hippler seems to be, you know, if I was on the defense team and I was an attorneys, I would feel like this judge is a really hardcore judge to go up against, because so far this judge really seems like he doesn't like me. And a lot of the motions that the defense has filed, the judge has severely called them out in these orders or even in the live streams in the court hearing. So, I mean, it could just be that conversations where it's like, hey, we're losing, you know, time after time, and we're just losing consecutively. Like, hey, Bryan Kohberger, maybe consider taking a plea deal because it seems like the evidence is just so overwhelming, and that, you know, at least take the plea deal and then, you know, not have to deal with the death penalty, right? So it could be that. Even if there's a shred of probative value in the proffered evidence beyond wild speculation excluded by RA 403. I hope maybe someday in the future he does an interview and talks about why he did it. I don't know, but then it could just be manipulation and lies anyways, right? Do we really care about that? Crazy. Likewise, here, presentation of the proffered alternate perpetrator evidence would pose a great threat of confusing the issues because it would force the state to defend against a nebulous allegation that perhaps these individuals were involved. This foray would lead to the jury astray. Oh, it rhymes. Committing its focus away from the defendant, whether the defendant, the only person whose actions are on trial, committed the charged crimes. It also presents a threat of unfair prejudice, as it would invite the jury to blame the unrepresented persons for a heinous crime when there is not a scintilla of competent evidence connecting them to the crime. The word scintilla also resonates for me because do you guys remember the ballerina murder trial, one with Ashley Benefield? I don't remember how to pronounce her last name. But she was destroyed by a judge. She was fighting with her husband about custody over her child, and she was essentially accusing her husband of poisoning her, poisoning the child, and doing some really crazy shit. And so at this hearing, the judge was like, there isn't a scintilla of evidence that supports anything that you're saying, anything that you're accusing your husband of. And then eventually she murders her husband, and then she has been found guilty of that recently. But yeah, that word scintilla, I always think of Ashley Banfield. Apparently, it would do nothing more than waste the precious time the jury and the court in what is already a scheduled 3-month trial. Nevertheless, the court's ruling does not preclude the defendant from confronting and cross-examining the state's law enforcement witnesses regarding the thoroughness of the investigation, particularly in following up and rolling out the leads generally. Again, they can, none of this is going to happen, right? Because he took the plea deal. Trial's not going to happen. But the judge was okay with having the defense, vigorously cross-examine the investigative team. So, pretty crazy. A chinchilla of evidence. I like that as well. The chinchilla of evidence. The court will apply the same parameters at trial regarding defendant's cross-examination of law enforcement. He may inquire as to the reasonableness of the investigation, including investigating, ruling out of the leads. He's not permitted to question law enforcement about the investigation of the specific individual as a potential alternate perpetrator without raising the matter with the court's outside jury's presence. Anyway, so yeah, while we were covering these two court documents and I was talking about how the judge, this was very scathing for the defense and pretty fucking crazy. They were supposed to have, they had their hearing today about witnesses that were going to testify, and some of the witnesses wanted to do maybe like video testimony or maybe not even testify at all or even be a part of this because they were like, well, I haven't interacted with Bryan Kohberger since like 10 or 15 years ago. So they had their hearing today, and then boom, all of a sudden we have this breaking news that Bryan Kohberger took a plea deal. He has pled guilty for the 4 murders, also for the burglary as well, in exchange for not getting DP. He's going to spend the rest of his life in jail, no possibility of parole, and then also no appeal. Now, I wonder if this is just kind of like a verbal agreement and it doesn't really go into absolute concrete effect until Wednesday, where they will have the actual hearing. So hopefully we'll be able to, hopefully we can, I don't know.